The framework for my oral argument,
Do you want to reserve any time for
I'd like
rebuttal?
to reserve 3 minutes, Your Honor.
3 minutes.
I'm sorry.
Thank you. Go ahead.
The framework for my oral argument has two subcomponents. The first one is to augment my brief, which heavily discusses the evidentiary standards for property valuation in the state of Tennessee in a divorce. Secondly, I want to respond to Appellee's brief, which in essence, as I read through it time after time, consistently says that we have violated Tennessee Appellate Procedure 27A and Court of Appeals Rules 6 and 7. On the issue of evidentiary standards, in our brief, we went into a lot of detail about how the Tennessee rules of evidence affected what happened in that case. I wouldn't have been hired if my client could not do what is required by the final order. It just wasn't true. And it's true that he would have a very difficult time, almost impossible, to bankrupt on an obligation. He may be able to pull off something on Chapter 13 on property valuation. That's a complicated issue. But we pulled a couple of lines of cases on property valuation. Sykes versus Sykes is a Court of Appeals case in 2021. It says the value of marital property is determined by considering all relevant evidence regarding value, and the burden is on the parties to produce competent evidence of value. Now, in saying that, I understand that we have an uphill battle no matter what condition my client is in. And the uphill battle is that most of the case law on this subject, when we come up to the appellate level, is very clear that the valuation of property in a divorce is not to be second guessed unless overcome by the preponderance of the evidence. And what we're trying to set forth today, Your Honors, is that our brief showed that there is absolutely no evidence supporting the wife's valuation of the property, which was adopted by the chancellor in Bradley County. Now, one case that that comes to mind to kind of define what I'm talking about is that valuation of, let's say, a house is to be as close to the final date of divorce as it can be. So you go back and you have evidence of what the house was purchased for, and then you go forward and you have evidence at the final decree of divorce as to what the house is valued at that time. Now, in our mind, in looking at the Tennessee rules of evidence, that cannot just be guesswork on the part of the wife. She can't just
How is the evidence presented in the record? Is there testimony about the valuation of these items, or is it just a list with proposed values?
Your Honor, thank you for the question. There is no transcript.
That's where I'm ultimately
I was hired
going.
on appeal, so as far as the statement of evidence, there is no statement of evidence. Now, I know I've been criticized for that, but on page 4 of our brief, I did clearly put in the designation of the record that there is no statement of the evidence. My main argument today is that there was no evidence, but it would be impossible for me, who was not the attorney at the trial level, to come up with a statement of evidence of what went on at a trial that I never saw.
And I guess that's my ultimate question, is if your argument is the evidence is insufficient to support the trial court's findings, but we don't have a transcript, how are we to evaluate the sufficiency of the evidence?
Your Honor, I am going on, first and foremost, the final order of Chancellor Bryant, and secondly, the remainder of the technical record, which I do believe strings together enough evidence to show that what happened was the wife valued husband's property, and that was immediately picked up upon and put in the final order. And that's the problem that we have with the first part of my argument.
Excuse me for interrupting, counsel. Did the
No
trial
problem.
court make specific credibility determinations with respect to property and valuation?
Well, Your Honor, I was looking at that issue last night, and I pulled two lines of cases, and I think that they are distinct from one another. The first line, I've got 11 cases, starting with Barrett versus Barrett, Court of Appeals 2002, that says the trial courts have wide discretion in making awards of alimony and the division of marital property, and are disinclined to second-guess such determinations unless they are contrary to the preponderance of the evidence. And what I'm trying to argue today, I'm trying to get away from credibility on the preponderance of the evidence, because I think the two are separate. We did find the line of cases on credibility, and we do understand that we're not saying the credibility of the valuation of the property, but the credibility of the person testifying is found to be credible by the chancellor, then that can only be can only be overturned on an abusive discretion standard. It's a very high standard they have to go by to overturn a credibility determination. And that's quite obvious because none of us were there. She was the only person there to judge it. But I do think that the line of cases that I cited before, specifically the two cases that I first cited regarding valuation of property, are born from a line of cases that absolutely has no mention of credibility. As far as, to go back to the second subcomponent of my argument, it was pointed out that a master asset table was not submitted. I amended my brief, and it's Exhibit 2 to the brief. On Tennessee Rule of Appellate Procedure 27A, we did put in our brief a table of contents, a table of authorities, a statement of issues, a statement of the case, a statement of facts, an argument, and a conclusion. The only thing I left out, Your Honors, was a jurisdictional statement. But if you drop down to Rule 27B, that can be excluded unless the court finds us wholly unsatisfactory in what we're presenting today. So I think that cures the 27A issue. Under Rule 6 of the Court of Appeals rules, again, as we talked about, Your Honor, there simply is no transcript, and we pointed that out when we filed our initial papers. And under Court of Appeals Rule 7, the master asset table that's required is Exhibit 2 to our brief. So the only other rule that was brought up against us was Rule of Appellate Procedure 24C. The way I would address that is on page 8 of our brief, we stated that there is no statement of the evidence. We are alleging lack of evidence in the technical record. My firm was hired for the appeal, and I cannot make up a statement of something that is not there or I did not see. I don't think that either one of us can talk about a statement of the evidence, to be quite honest. Finally, there is an argument for attorney's fees. I don't see any merit in that. The appeal is not frivolous. My client hired me because he can't do what he's required to do. under the Tennessee rules of evidence, there is no proof that he does. It's all conjecture. And in my mind, attorney's fees have consistently been requested the attorney's fees in this case were requested in violation of the American rule where each party pays their own attorney's fees. There was a TCA section, it was 27-1-122 that was cited for interest in attorney's fees on the other side. It doesn't apply because for that statute to apply, the appeal has to be either frivolous or taken for delay. And it was certainly taken for husband's survival because he would have a hard time bankrupting on an obligation. And essentially, we understand on the major issue, it's an uphill battle to show that, there was not a preponderance of the evidence. But from what we can read from the technical record and the final order, which we believe is enough for our argument today, we believe that the court should have dug deeper, demanded more significant proof of the statements that were made by the parties as to property valuation. We think that it's a violation of several of the Tennessee rules of evidence that we submitted in our brief not to do so, and we would ask that the case be remanded. Yes, sir.
How do we know whether or not an objection as to violation of the rules, how do we know if there was any objection made to the testimony?
There's no way.
Yeah. Okay.
Thank you.
You have your time for rebuttal.
3 minutes.
Yes, sir.
Yes, sir.
We'll hear from the appellee.
Good morning.
Good morning.
Need to move that a little bit. My name is Amy Campbell, and I haven't been here for 20 years, so it's very nice to see your faces today, and I appreciate you hearing my argument.
Glad to have you both here.
I represent Ms. Jennifer Self, and I represented her at trial. So I do know what the evidence was at trial, but we do not have a statement of the evidence, nor do we have a transcript. I had planned on discussing more what I have in my brief, but I feel like it sets things out pretty well, so I'm going to basically respond to what Mr. Jones said. First, as far as the evidentiary standards, he cited, I believe, the Sykes versus Sykes case. He said he pulled it last night. And said that the burden is on the parties to produce competent evidence of the value of property so that our chancellor can evaluate what is what in a divorce case. In this case, we did have a master asset list, which is required by our local rules. I typed it up. It listed the property of the parties, and the first several pages are designated marital property, and that is key. That it is marital property that is in those first few pages because that's by far the bulk of the party's property, and that it was marital. Because Ms. Self has an interest in the marital property, she's allowed under Rule of Evidence 701 to testify as to the value of that property. So on its face, and based upon everything we know to be true, she's allowed to testify what she believes the value of her own property to be. It was not husband's property that she was valuing, as set forth in the brief, and as Mr. Jones mentioned, it was their joint marital property that she valued. So she was allowed to value that property. Where we have the problem is that Mr. Self simply did not participate in valuing the property at all. In most cases, in almost half of the items of marital property, he simply said they didn't exist, does not exist, and that was his testimony. And the court found that to be not credible. She even said that if he had given some reasonable explanation as to why these things did not exist, that she would have she would have potentially believed it. She would have listened to it and evaluated his credibility. But because he simply said these items of property did not exist, she was working in an information vacuum. All she had was the appropriately listed property by my client on the master asset list as marital property, and my client's valuation of that property, which was proper under Tennessee Rule of Evidence 701. So she had to go with the only information that she had if she found that my client was credible, which she did, specifically in her final order. She also credited the testimony of my client's corroborating witness regarding particularly the existence of the items of property at the time of separation. In the final order, you will read that the court found as evidence of inappropriate marital conduct that the husband left the wife 2 to 3 years prior to the trial and took property with him, and then if it didn't exist, which was what his testimony was, that he dissipated the asset. And that is grounds for divorce. He left, he took everything of value and took off with it, sold it, or did whatever he did with it. So she cites that in her final order. She didn't simply just adopt what my client claimed was the value. She went with the only evidence that she had because husband refused to provide any evidence. I understand that Mr. Jones wants to get away from the idea of the credibility of the parties and the other witness, because we only had the one other witness, as far as related to the preponderance of the evidence, and should we overturn the trial court's ruling as an abuse of her discretion. But she has an amazing amount of discretion in determining the credibility of witnesses. She's obviously in the position most amenable to determining, do they appear credible? Are they making eye contact? Are they speaking from knowledge, from personal knowledge that makes sense? She was able to do that with both my client and Mr. Chisholm, and also Mr. Self. We can't get away from credibility because it's key. We have to look at her determination of credibility of these witnesses in order to determine whether she abused her discretion in valuing the property as she did. Now, as far as Rule 7 goes, the table that Mr. Jones amended his brief with, I bring this up because it seems nitpicky to say he didn't put the right table in his brief. It truly does. But if this case actually had a record and there was no table, the court would be going spelunking to find out what exactly happened at trial with the valuation of these pieces of property. And I would argue, even with the table that was presented, you still have to go spelunking. Luckily, there's not that big a cave. What Mr. Jones did was to take the master asset list that was already part of the record because it was attached to the final decree of divorce as Exhibit 1, and was also Exhibit 1 at the trial. And he didn't provide the additional things that Rule 7 requires. Rule 7 wants to identify the property, evaluate the property, tell us what husband said, tell us what wife said. Tell us what the court valued the property at, tell the distribution that the court made, and cite to where in the record that discussion occurred. What Mr. Jones did when he filed his amended brief was to leave out anything that the court did. What did the court determine the value to be? To whom did the court give the property? And where in the record does that appear? So it is still deficient, even after having the opportunity to fix it. In this case, is that hugely determinative? No, but the rules are here for a reason, and they should be followed. On the Rule 6 issue, I think we have no record We have no proof of any evidentiary objection being made at all during the trial of this case, whether by me or whether by Mr. Self's trial counsel. There is no proof that any issue related to Ms. Self's credibility, Ms. Self's ability to value property, whether the property should be on the master asset list as marital or separate, which, by the way, the parties stipulated to, and it's in the record in the final order, that the parties agreed that the master asset list was complete. Master asset list as marital property from the very beginning. I also want to just point out that this case was tried in 2 different days, months apart, one in April and one in August, because it was COVID. And the first time we were on Zoom and technology was not cooperating. So we set a return date when we could come and do it in person. So the judge was able to sit in front of the witnesses as they testified and judge their credibility. During that period of time, the master asset list was Exhibit 1 to the trial. If Mr. Self wanted to make changes to whether or not it was really marital property, what the value was, whether it existed, it may have been an uphill battle to change the master asset list once it had been stipulated to, but it wasn't done. There was time, there were months between the first hearing and the second hearing for any evidentiary issues related to value to have been addressed at the lower court level, and they weren't. So if we can't cite to the record where the judge abused her discretion, we cannot find that the judge abused her discretion. Regarding whether or not this is a frivolous appeal, I don't believe it is. I don't know that this is a winnable appeal. I understand Mr. Self's position. We were very successful, Ms. Self and I, at the trial level. He may feel as though he cannot comply with the court's order. But the order says what it says, and it was allowed to be entered as a final order without any sort of motion to alter or amend, reopen proof, or do anything of that nature. So we're left with the opportunity to appeal. But it is causing my client to have to incur more attorney's fees in order to argue an information vacuum, essentially. As far as the American rule on attorney's fees weren't granted just because the judge wanted to. Attorney's fees were granted as part of alimony in solito. The judge went through all of the factors in her ruling that were applicable to these parties related to the duration of the marriage, the need and ability to pay, the fact that the wife had cancer, was on a restricted diet, unable to work, clearly found that she was the financially disadvantaged spouse, went through the entire analysis, and that is why alimony in solito was granted as far as the attorney's fees, and then alimony in futuro was also granted. And all of those things were discussed as they should have been and included in the final order. So the best indicator of what the court heard and believed is right there in the final order. It shows no abuse of discretion under any analysis. And we ask the court to affirm the trial court's ruling.
Thank you. Hear from the appellant, rebuttal.
Your Honors, Ms. Campbell mentioned competent evidence was the first thing. I agree that competent evidence goes both ways. It applies to my client, it applies to her client. I'm just saying today that there was no competent evidence and that the master asset list and valuations by the parties require something more than just uttering what they think the other party's property is worth. I'll cite a few examples. A 1982 Chevy truck valued at $40,000 A 1999 Dodge Ram that husband does not have, valued at $15,000. A 2008 Chevy Avalanche that he doesn't have, valued at $28,000. His own work tools, which he never even really used at home, he used in his job as a mechanic, valued at $50,000, twice in the master asset list. Totally, the chancellor found that my client had $200,000 worth of property, and not only that, he had the ability to pay a lump sum payment of $53,000 within 2 months of the order, which he didn't have, and then $850 a month in alimony, which is about $10,200 annually. His income was, it said he had the ability to make up to $40,000 because all he was able to get was one income statement, and it showed that that year he made $40,000. Well, as an auto mechanic, it goes up and down. So he can't afford all this. My point is that trial was kind of messed up when it was split up. I think that there was not enough digging into evidentiary standards, the Tennessee rules of evidence, what the parties needed to support their evaluations. And it's my respectful opinion and request today that the case be remanded to be redone with a proper following of the Tennessee rules of evidence. It's been a pleasure talking to you all today, and thank you for allowing us to argue.
Of course, thanks to both counsel, and enjoy your drive back to Cleveland. Recess court till 1:30 this afternoon.